Appeal in the matter of Hipgnosis SFH 1 Limited and Manilow and...
My lords, I'm grateful. Could I begin just by expressing the gratitude to the parties that could convene itself at such short notice to hear this?
And on a Friday.
And on a Friday. To make matters worse. But
we can perhaps debate at some point the logistics of what you want from us.
my lord, yes.
So let's do that at the end of the hearing.
My lord, yes.
We
What I'm
don't have
proposing,
a transcript, do we, or do we?
I don't think we have. Not that I'm aware.
Only ask in terms of how detailed the note one takes.
My lord, what I'm proposing to do is to deal centrally, obviously, with the point of construction of the relevant clause, which is at the heart of the appeal. Before doing so, I just want to deal with some factual points, which loom large in my learned friend's skeleton. There's a narrative that they put forward and invite the court to accept. And it's a theme which runs through their submissions, and I just want to scotch it at the outset. And that is this, my lord, it's suggested that the commencement of the claim was, to use my learned friend's phrase, improper forum shopping.
Well, that argument isn't open to him because the judge found that the proceedings were properly brought in England.
Indeed.
And there's no respondent's notice or cross-appeal or anything of that kind. It's a serious allegation which shouldn't be made unless there's a basis for it.
Well, my lord, indeed. I will just run very briefly through it because I think my learned friend is going to pursue it. And my lord, also not just improper forum shopping, that we commenced the claim only for tactical reasons.
Well, how can reliance on an exclusive English jurisdiction clause in England be improper forum shopping?
Well, indeed, my lord. Indeed. But my lord, even if though one looks at the factual background, and if we could do that very briefly, because it's all quite wrong on the evidence, quite apart from what the contract says.
Okay.
And if one looks at it, one can really take it from the chronology of events at tab 5 in the main bundle.
Okay.
My lord, the starting point in the chronology is obviously the acquisition agreement. And I think I don't need to take your lordships to it, but your lordships will appreciate that that provided that if and to the extent the defendants received monies referable to the assets purchased, here in this case they're called the Sony receipts, the defendants were obliged, A, to report that fact to us, to hold those monies on trust and to pay them over to us immediately. Now, what happened was that from March 2023, the defendants ceased to pay over the Sony monies. They just retained them. They didn't even report their receipt. That obviously generated many demands for payment. And one sees at the bottom of page 29 in the bundle, the various demands are recited and they're referred to in the particulars of claim. And the sole basis upon which they were not paid over was apparently the suggestion that additional purchase price was due to the defendants, which of course was not a reason not to pay them over because the contract provided that they should be paid over without set-off or capital credit. That remained the position, i.e. that the defendants were effectively holding this money to ransom through until, and one can pick it up in May 2024, when the letter was written, which the judge refers to, by the defendant's American attorney, in which it was asserted that my clients had no legal recourse to the monies that were being held by them on the basis that the additional purchase price was due. That letter, my lords, appears in the supplemental bundle at page 48.
Yeah.
And in particular, they set out their various contentions, including that the non-payment of the additional purchase price was a repudiatory breach. And then at the bottom of page 50, as your client, due to its own material breaches stated above, is actually better off than where it would be, where it would otherwise be where the agreement adhered to its strict terms, it has no right to legal recourse as it cannot prove the essential element of damages. So that was in May 2024. My Lord, then, after all the demands and all the correspondence, we did not rush off to court. We didn't go to court in May, we didn't go to court in June, we didn't go to court in July. They continued to hold on to this money as ransom for their, we say, baseless demand for an additional purchase price. The claim was eventually started in August, but to suggest that this was a case of us rushing to beat the defendants to the clock is simply baseless. Even come August, there's no evidence that the defendants were on the point of issuing proceedings. The only evidence that was before the court from a witness was the evidence of Mr. Dando, which is in the supplementary bundle behind tab 2. I don't need to take the court to it, but he does not suggest in that statement that the defendants were on the point of issuing California. On the contrary, the defendants had months in which to bring their claim in California, but they apparently preferred to hold the trust money to ransom in the hope that it would bring us to the table. Even when they did finally commence proceedings at the end of August 2024, they weren't served until the 18th of October 2024, for which Mr. Dando provides no explanation as to why they were sat on for all that length of time. So, as the judge found, my lords, the claimants were entirely justified in bringing the claim as it did, when it did. Indeed, as my lord has already pointed out, the claimant had no option. It had to litigate in England. Far from thwarting the contractual bargain, as we're said to have done, we were complying with the contractual bargain.
On your case as to the correct construction of the clause, it doesn't really matter who went first.
No, doesn't matter. No.
Because the effect of an asymmetric jurisdiction, or one consequence of an asymmetric jurisdiction clause structured like this one, is that there may be parallel proceedings in two jurisdictions.
Indeed, my lord, that is inherent in
It's inherent in the nature. And I think that's what Lord Justice Henderson said in Etihad. Or somebody said it anyway.
yes, we'll come to
sure.
authorities on it, but my lord, yes. So, my lord, it was perfectly proper for us to commence proceedings, and as the judge has also held, it was perfectly proper to include negative declaratory relief as part of what we were seeking. Indeed, it would have been senseless not to, in circumstances where the only defence that we could see to our claim was the alleged set-off. Now, my lords, in order to be lectured in this way by the defendants in circumstances where, while we scrupulously abide by the contract, the defendants, by contrast, have acted in flagrant disregard of their obligations as trustee in relation to the withholding of money. And my lord, I can say that now because the defendants have not put in any defence to that claim. They don't even attempt to justify their conduct. And my lord, not only were they in breach of the contract in that regard, they were in flagrant disregard even in relation to this jurisdiction clause. And I say that, my lord, because they are pursuing claims in California, as you will be aware, for not merely payment of the additional purchase price, but for fraud and negligent misrepresentation. The complaint in the Californian proceedings, i.e. the particulars of claim in effect, can be found in the bundle at tab 3E, the supplemental bundle, I'm sorry.
Yeah.
Page 52, and I don't think it's going to help to go through it now, but it's, your lordships will see, for example, on page 60.
It's an allegation of fraudulent or negligent misrepresentation in pre-contractual negotiations.
Page 60 is where the fraud and fraudulent misrepresentation claim is articulated, and then at page 62 one sees the negligence claim.
But, and you say, well, given that that is, on any view, either whether it's a contractual or a non-contractual dispute doesn't matter because the clause covers both.
Yes.
That's fairly and squarely within the first and second sentences of the
Indeed.
clause.
We submit unarguably so, and the defendants are plainly in breach of the jurisdiction agreement. That's a point I'll return to if we need to get to questions of discretion. But I'll come back to that. The second, that's what we say in relation to this general theme of my learned friends, that we are somehow acting improperly.
Yeah.
The second point is this. My learned friends suggest that the claim in relation to the withholding of the Sony monies is more or less agreed now. Just to make clear in relation to that, that's not the case. Although the defendants have not put in a defence, the position has slightly developed. And if I could just invite you to take the unagreed bundle, supplemental bundle 2, which contains some correspondence arising since the judge decided the case below, and it's agreed that the court did look at this. The unagreed bundle. Now, your lordships may have picked up that as pleaded, our understanding was that Sony had paid 2 instalments, 2 half-yearly accountings to the defendants, and had thereafter ceased suspended payments pending resolution of the dispute. And what happened, if your lordships look behind tab 3 of this bundle, first of all, at tab 3, the defendant gave notice that they weren't putting in a defence to that part of the claim.
Hang on a second.
That's the final sentence on page 57. Tab 4, those instructing me responded, and specifically at page 59, they set out, first of all, what they understood to be the sums that had been paid over to the defendants.
That's the following page.
That's the following page, page 59. And in the box at the top are the 2 sums which we had understood the defendants to have received. And then below that, one has the box where those are the payments which we understood Sony to have suspended. And what we asked, in particular, at number 1, does your client admit that the first table reflects precisely and exhaustively the principal sums received by the defendants? And point number 3, will your clients give an undertaking that neither they nor anyone else has received any other sum, subject to clause 4.4? The answer to that one sees at page 63, where first of all, numbered paragraph 1, there is some quibbling with the second, the amount of the second payment. I don't use quibbling in a critical way, but there's a dispute taken as to the detail of that. And then in point 3, in relation to the request for the undertaking that the 2 payments were the only payments, it was said this is a request for relief not sought by your claim and we don't address it. Now, there was then further discussion, and there's still dispute between the parties in relation to interest and costs. But what happened, fortunately nothing was signed off, because if your lordships turn to tab 12, those instructing me spoke to Sony and found out, this is picking it up at page 71 by the second hole punch. Today our client has been advised by Sony that contrary information previously provided. Sony had in fact also accounted and paid the accounting due for the accounting period second half of 2023. And one sees over the page the sum involved, $293,000. So extraordinarily, the defendants have been sitting on this $290,000, knowing that we had been told by Sony that it had been suspended. And they never volunteered, and indeed they even led us into signing a consent order on the basis that only 2 payments had ever been received. So, my lord, I draw this attention to the court because it is far from the case, therefore, that the money claim is agreed. As things stand, as I understand it, the defendants are not accepting that they received that money. And so there may well have to be a dispute as to that issue.
So you plan to amend?
We'll have to amend if that remains the position, yes.
Yeah.
So, well, that's the position on the money claim. And against that background, then, I'm going to turn to the...
Where's the yeah, sorry. Yeah, I was going to say that, I mean, the assertion that, your clients haven't pleaded it, not really sorting the claim is incorrect because you sort an account.
Well, indeed, my lord, yes. I in answer to my lord Justice Phillips' point about amendment, we do specifically plead that our understanding is that 2 payments were made and Sony has suspended the rest.
You need to
So
amend,
we need to amend
technically
that.
amend, but
Yeah.
insofar as there's a claim for other sums received, it's within the claim for an account and a payment over pursuant to the account.
Indeed, indeed.
So there's either a defence to that or there isn't.
My lord, yes. And there is...
Your real point is that the assertion that this is now only about the purchase price is just factually incorrect.
Indeed, indeed.
Yeah.
In submitting to judgment, were they going to agree to give you an account?
Well, I think the parties, on the basis that the figures were capable of agreement, I think the parties were going to cut through that process and agree the figures. So as I say, there remain disputes about interest and costs and the like. But as things stand here today, even the figures can't be agreed. So, my lords, against that background, I hope not overly long, I'm going to turn to the central question in relation to the interpretation of clause 14 of the agreement, which we say is clear and absolutely straightforward. I'm going to take it from tab 11 in the core bundle. The full agreement is elsewhere, if your lordships prefer to do it from there. This isn't a case where I think the court gets much assistance from other provisions in the agreement in relation to clause 14 itself. And it's comprised of various sentences doing various things. The first sentence, obviously, is a choice of law clause, applicable regardless of jurisdiction. The second clause is key, and your lordships can read it to themselves, but it is providing in the clearest and most unequivocal terms that there is an irrevocable submission for all purposes to the exclusive jurisdiction of the English court. Then the third sentence I think we can pass over, and it's the fourth sentence that gives rise to the issue. Notwithstanding the foregoing, any claims made by BM, I stress those words, any claims made by BM against Hipgnosis related to the purchase price may be brought by BM in the courts of Los Angeles or New York, and solely in connection with such claims. Hipgnosis agrees to submit, etc. Now, that sentence, the fourth sentence, is, I don't know whether one decides to carve out derogation. It, in some sense, cuts down or provides an exception to what is in the second sentence. And hence, the phrase, notwithstanding the foregoing, one can read that as, despite the apparent and total reciprocal exclusivity given by the second sentence, there is an exception to that, but it is an exception which applies only in certain circumstances and to certain things, namely any claims made by BM against Hipgnosis related to the purchase price. It is limited to claims made by the defendant in relation to the purchase price. It has no effect whatsoever and says nothing about the jurisdiction in relation to claims brought by the claimant. My lord, I'm not really sure what else one could say about this, although I will strive to. But, my lord, it is absolutely straightforward and obvious that in relation to this claim before this court, the fourth sentence has no relevance.
I mean, it's the context in which asymmetric jurisdiction clauses have been considered previously by courts, really mean financial instruments of one kind or another, where it's usually the lender has a right to sue elsewhere. Sometimes in a particular jurisdiction, usually it's a general provision because the lender will want the ability to basically pursue the borrower wherever the borrower has money, which is understandable. But in the only difference in terms of how this clause fits together, if I can put it that way, and its overall intention is just that last bit which says, in effect, that you will submit to the jurisdiction of either California or New York in that event.
Yes.
For the purposes of a claim by the defendant.
Yes.
But that says nothing at all about whether you can bring a claim yourselves for any part of the contract.
No, my lord, it's a distinction. Well, we'll come to it's a distinction without a relevant difference for this purpose.
Yeah.
And as I'll come to, any other conclusion involves effectively accepting the proposition that my client has contracted out of the ability to bring claims related to the purchase price, which, for reasons I'll come to, cannot possibly be right.
Well, this is a jurisdiction clause, and the contention seems to be that it should be construed as a clause which prevents from suing
Indeed.
for those matters at all, anyway.
Which would be contrary to public policy. One can't contract out of access to justice in that way. And to read the clause as having that effect, which even on my learned friend's view and the judge's view involves importing a lot of machinery about circumstances in which proceedings have to be begun, etc., come to. But my lord, it's simply not what the language says.
I wonder how this is left in the light before us, because the judge found, contrary to that argument, that you could sue in England and that the proceedings were correctly brought here. He expressly found that.
Yes.
And that's not challenged by
No.
the respondents.
No. So
I'm not sure what's before us in that regard, because the time to consider whether there's jurisdiction is when the proceeding.
one would very much have thought so, my lord. Yes.
Well, it's established by authority in this court.
Yes.
And the judge found that there was jurisdiction when you commenced the proceedings. That's the end of it.
That was very much the way the submission was put to him. He obviously relied on this idea of a floating jurisdiction,
Yes.
which I think, to be fair to Mr. Sutcliffe, wasn't quite the way it was presented to the judge. It's a I don't mean to be rude, but it's something he created.
Do you rely upon the fact that the judge found, I can't remember which paragraph, that you proceedings were properly brought and served?
Yes, I very much do rely on that, my lord.
And the fact that that's not challenged.
That's paragraph 18, my lord.
So the argument that there's some negative obligation not to sue in England, I'm not sure how that can be advanced, because the judge has found proceedings were properly commenced, and that's not challenged.
I think the way it's put is that somehow jurisdiction is lost by virtue of the commencement of proceedings in California.
There's a decision, CA Indisuez, in this court, where this court expressly held that the time to judge jurisdiction is as at the date of issue.
My lord, in a way that arises just from the rules, but by law we can certainly dig that out over.
I mean, one of the issues is, if you can lose jurisdiction, what happens about limitation? Party commences proceedings within the limitation period, and the court says, I'm sorry, you've lost jurisdiction.
My lord, yes.
By which time the limitation period is expired. Well, what happens then?
My lord, there are various problems that might arise, and it's just an extremely odd notion that one can have jurisdiction at commencement in circumstances where the rules provide that if there is a jurisdiction clause, you can serve out without permission. And then suddenly it's lost by virtue of some supervening factor. Certainly, I'm not
It's
aware
not
of.
entirely clear what the judge thought was happening, if I can put it that way. Because as my lord says, he finds in terms that the proceedings were properly commenced and service out was regular. I mean, he seems to have thought that the defendants, that the fourth sentence which gave the defendant an option, let me put it that way, somehow trumped the second sentence if the defendant did exercise that option.
Yes, I think he would
That
say
seems to be what he's
within a reasonable time.
But I
think
mean,
he
that's
would-
absolutely, that completely ignores the fact that the second sentence is an exclusive jurisdiction clause.
Indeed. My lord. But as I apprehended, that's the way he saw it, and that's why he talked of floating jurisdiction. That there was a jurisdiction at the time, the court had jurisdiction when issued, and indeed served. Well, I say so. It's not clear from the judge's judgment when it is that the floating jurisdiction floats over to California. In that paragraph 18 seems to suggest that it occurs, he talks about by commencing the Los Angeles proceedings within a reasonable time, the commencement of the English proceedings by sea and by making the application. It's not clear whether he's saying that the jurisdiction floats over to Los Angeles upon the second of those events or upon the first of those events. And that might have a bearing on things, because it then might become important as to whether we served first or not. But all this is obscure, and we say just simply doesn't arise on the basis of the clause, because the clause simply doesn't contemplate any of this.
The previous paragraph 17, sub-Roman 5, has a series of sub-paragraphs between A and F.
Yes.
Does seems to be what his thinking was that whilst, well, in effect, that so far as the purchase price was concerned, there could only be one jurisdiction.
Yes, my lord.
And even if you commence proceedings first in England, if the defendant chose to then pursue proceedings in Los Angeles or in New York, the effect of doing that was, as he puts it at the end of F, to retract the defendant's otherwise irrevocable submission to the English jurisdiction.
Yes.
So it wipes out the exclusive jurisdiction clause.
And that, as I understand, is very much the way my learned friends put it. They
That's
say...
a sort of, that's his point about a floating jurisdiction clause.
Yes.
It doesn't really... it's a novel concept.
It's a novel concept. And
there are cases about floating proper law.
Yes.
And there's some debate about that going right way back to, I think, to Dupont and Agnew, and perhaps even earlier than that, Mr. Justice Bingham at first instance. I forget which case it was, the Iran Rajan or something. I think they're all in the bundle. But that's not what this is not about a floating proper law, about changing your proper law.
Yeah.
And that's what's contemplated there is a possibility that you have a proper law of the contract at the outset, and then there's an ability to change what is the proper law at some stage. The clause would need to say that in terms, and here you nothing to suggest that the second sentence of the clause is somehow disappears at some point.
No, on the contrary, the fourth sentence is specifically limited to claims brought by the defendant.
Yeah, quite.
And that's a key point which, in my respectful submission, the judge just ignored. He instead focused on the related to the purchase price and found that there must be some sort of exclusive jurisdiction in relation to that. But as I'll perhaps develop, the logic of that, though, is that my clients have contracted out of the ability to bring claims in relation to the purchase price, which we say would be an extraordinary proposition. And certainly not one that one can collect from the express words. Now, my lords, I've set out in our skeleton the responses we make to the specific subparagraphs of 17.5, and I'm not going to go through those now. But we say that at the end of the day, it's simply that the judge's interpretation just is not possible to arrive at on the express words. And he completely overlooked the fact that the fourth sentence is only concerned with claims brought by the defendant. And to suggest that the English court loses jurisdiction once proceedings are commenced elsewhere is simply not what the clause says. My learned friends seek to suggest that one might get to that result as a matter of implication. But we say that can't possibly pass any ordinary test for implication. It wasn't the judge's approach. Such an implied term, whatever it is, wasn't contended for below, and it hasn't been formulated for the court now. And it raises all sorts of issues about what the implication would be about, for example, within what time the proceedings in Los Angeles or New York have to be
You can't
commenced.
imply a term which is inconsistent with the express terms of the contract.
Indeed.
You say the second sentence is an exclusive jurisdiction clause.
Indeed.
No amount of implication can get you around that.
Indeed, my lord. But even if one tried to, one wouldn't be clear about what the term was. How long do they have to commence proceedings? Does the jurisdiction shift at the point of issue or service, or when the application is issued under Part 11? All of that would remain to be argued over. The judge approached it, as your lordship has indicated, on the basis that there has to be one jurisdiction for purchase price claims, if I could use that phrase, claims related to the purchase price, and it must be the one chosen by the defendants, to which one just simply says, well, why? That's just not what the clause says. And if one considers, for example, as I referred to in the skeleton, what if we had a claim because we had paid the additional purchase price under a mistake, and it turned out that the thresholds for it being earned hadn't been met for some reason, so we had a restitutionary claim. On the judge's view of things, and on my learned friend's view of things, we can't pursue that in the English court, or if we can pursue it, we're liable to have the jurisdiction of the court defeated by some.
You can't pursue it anywhere, I think.
Well, indeed, we can't pursue it. We certainly can't pursue it in America because we're subject to second sentence. Indeed, that's the point. So we have effectively disabled ourselves from pursuing such a claim.
Well, I think Mr. Sutcliffe's argument is that you can't pursue it anywhere. I think the judge's analysis is that you can pursue it in England, but then if the defendant commences proceedings in California, you lose that jurisdiction.
I lose that jurisdiction, yes. And we'll come to what my learned friends have a particular point about that they think they can solve this problem, but we'll come to that.
It's simply that that's not my argument, my lord, that they can't pursue it anyway.
But my lord, I'll come to that in a moment, if I may. But we say that this is simply not a result that follows from the language and would be a most extraordinary proposition. Now, your lordships are confronted today with a welter of authority from my learned friends in relation to the approach to jurisdiction clause generally. I'm not going to go through all of that. Most of it seems to be directed at two connected points. First of all, to establish, for example, the willingness of the court to read into a jurisdiction agreement that it is exclusive, even if it doesn't say so. Well, that doesn't really take one very far, because here, the second sentence is quite clear in terms that it is exclusive. The second, more general proposition is to rely on what one might call the one-stop shop presumption from Fiona Trust. That's an odd proposition, since it's my learned friend's case. They expressly rely on the fact that this wasn't a one-stop shop. The parties have agreed exclusive jurisdiction for all claims brought by the claimant and all claims brought by the defendant that aren't related to the purchase price. And they've agreed a quite separate jurisdiction provision in relation to potentially claims related to the purchase price. So it's an odd proposition for my learned friends to be relying on the one-stop shop presumption.
It's even more than that, isn't it, really? Because they could have commenced proceedings for the purchase price in England.
My lord, yes.
They're perfectly entitled to do that.
Yes.
And you wouldn't be able to say, oh, hang on a moment, you've got to pursue that claim in California, even if you wanted to say that. But I mean, that's not what this clause says.
No.
It doesn't say, it's not an either-or clause. And that the one-stop shop point is really an either-or point. And the answer to it is to look at the express words of this provision.
Indeed. What I think my learned friends suggest, and this gets, I think, to the nub of what the judge found, is that it's a modified version of the one-stop shop presumption, is that one looks exclusively at claims related to the purchase price, and one construes it as providing for an exclusive jurisdiction in relation to such claims, i.e. you simply ignore the words that the fourth sentence only relates to claims brought by the defendant. Now, we submit, is simply not what the clause says, and it is not, in any sense, an orthodox or sensible way of applying the one-stop shop presumption. And it has the effect, as we've said, that the defendant, in effect, that only the defendant could commence claims in relation to the purchase price. That's where it ends up. Or, in a slightly modified version of that, if we do commence such claims here, they're liable to be ousted by some subsequent claim brought by the defendants. And we say that cannot be right, and it would, in effect, prevent us from making a claim for restitution of a mistaken payment, as I said. In relation to that point specifically, I said it's going to come back to what I think the defence do say about that. They say at footnote 12 to their written argument, they seem to accept the proposition that if we commenced proceedings here for a mistaken payment, they could defeat that claim by commencing perhaps proceedings for a negative declaration in Los Angeles or New York. So they seem to accept that's the effect of the clause, which we say is bizarre. They then say that the answer to that is that they could counterclaim. We could counterclaim in the Californian courts. Well, as to that, we say first of all that wouldn't be permissible. We couldn't counterclaim in the Californian courts because under the clause 14, we have to pursue all claims in London. And any counterclaim we wanted to bring in the Californian courts, we couldn't bring because it doesn't fall within any exception that we can rely on. The second point is, we don't know anyway what the rules for counterclaiming in Los Angeles or New York might be. We don't even know if it's possible. It may be relevant to note, just to look again at the letter from the defendant's attorneys on the 2nd of May in the supplemental bundle.
Yeah.
At page 51, we looked earlier at the section where they say that my clients have no legal recourse. They then go on to refer to the jurisdiction clause, and they say halfway down page 51, this gives my client the right to bring a civil action for those payments in Los Angeles, but does not allow your client to bring any claims in that field. Should we proceed to litigation, my client can and will pursue 1.5 million plus attorney's fees in Los Angeles, while your client can pursue a claim for peanuts in the United Kingdom. So he's evidently taking the view that we couldn't counterclaim or set off in California. We would have to be stuck here while he can recover his $1.5 million there.
Yeah.
So on that basis, it appears that a counterclaim wouldn't be permissible if they sought a negative declaration as to a mistaken payment. Certainly there's no evidence that it would be. And finally, my lords, even if it were possible, can the parties really have intended that there should be this sort of Baroque structure that if we want to pursue a claim in relation to the purchase price, we can't commence a claim in California or New York. We have to commence a claim here and wait for the defendants then to make a claim for a negative declaration in the jurisdiction of their choice, have a claim here stayed, and then pursue a counterclaim if it's possible in the American proceedings. My lords, the parties cannot conceivably have intended that sort of Baroque structure. And if that is where adoption of the Fiona Trust presumption leads you, then something's gone very badly wrong with that presumption. My lords, the only two authorities that really assist on this point, we say, are Lorna Mead and Mauritius Continental Bank. And just to take them very briefly, chronologically, Lorna Mead is the first one. It's a decision of Mrs. Justice Gloucester.
Yeah.
Two. Hang on, I'm sorry. What time is it? It's bundle 1 of the authorities. I'm sorry, behind tab 15. And your lordships will see page 223. The judge introduces it by setting up what the relief that it's sought. It's essentially relief to the effect that the claimant borrower is not liable in the events that have happened in relation to various finance agreements.
Yeah.
The relevant jurisdiction clause, I'm sure the form with which your lordships are familiar, is set out at paragraph 7 on page 224, 225.
Yeah.
It's in a sense a standard finance party form of clause. The bank argued that although there was although there was jurisdiction given to the English court for proceedings brought by the borrower, one of the bank's arguments was that, well, it could in effect renounce that because the clause was given for its benefit. And the argument is articulated by the judge at paragraph 111. The argument was based in part on Article 17 of the Lugano Convention, which in this case, but which provides, as set out in paragraph 111. And what Mrs. Justice Ross says, I don't accept Cowting's final submission that because the English jurisdiction clause are expressly stated to be for its benefit and not Lornamede's, it's entitled under Article 17 to renounce the clauses in relation to this dispute, and it's done so. First, it's clearly too late for it to do so once proceedings have been issued by Lornamede, and that's perhaps my Lord Justice Phillips' point about the point is what is the position as at the date of issue, and it can't subsequently be changed. It's done afterwards. And she then says it's not sustainable on the wording of Article 17 or on the wording of the relevant English jurisdiction clauses. She then refers to Article 17. This does not confer on Cowting an entitlement to renounce the jurisdiction clause in its entirety and dispute the jurisdiction of proceedings properly brought by another party in accordance with the clause. The article merely provides that the beneficiary of the clause is permitted to elect to bring proceedings arising out of or in connection with these proceedings in another court. But that provision is clearly given the wording in any other court which has jurisdiction. It doesn't entitle Cowting unilaterally to challenge proceedings previously brought by Lornamede against Cowting in England in accordance with the terms of the English jurisdiction clause and in conformance with Lornamede's contractual obligations thereunder, nor do the English jurisdiction clauses confer any such right. So she's deciding the point not merely on the basis of Article 17, but also by reference to the specific terms of the clause. Then the point arose again in the next authority in the bundle, which is Mr. Justice Popplewell, Mauritius Commercial Bank. Here, the boot was on the other foot, if you like, in that it was the lender bringing proceedings in the basic jurisdictional home of the claim, i.e. England, and it was the defendant borrower who was seeking to challenge it. The clause in that case is in pretty much identical terms, page 282 of the bundle at clause 24. And the argument which the defendants were putting forward is summarised in very broad terms at the bottom of on page 904 of the report, paragraph 12. Alternatively, it's submitted that if clause 24, when it's governed by English law, it's too one-sided to be compatible with fundamental principles regarding equal access to justice. And that is picked up in particular at paragraph 40 of the judgment on page 289 of the bundle, where Mr. Justice Popplewell says this: it's further contended on behalf of the defendants that clause 24(1)(a) confers no rights on Hestia or Sujana because MCB's freedom to litigate in any forum under clause 24.1(c) applies regardless of whether MCB is sued or is being sued. The argument is that clause 24.1(c) operates defensively to enable MCB to resist any suit brought by Hestia or Sujana in England because it provides that 24.1a is only for C's benefit. Accordingly, it said the clause is entirely one-sided because it confers no rights on Sujana or Hestia to sue in any forum while subjecting them to any forum at the suit of MCB. Now, my lords, that's very like the submission that's being made here, or what the judge found, i.e. that although there is jurisdiction granted to the English court by the second sentence, the fourth sentence can be used defensively by the defendants to defeat that. And Mr. Justice Popplewell, not surprisingly, said that is, in my view, an erroneous reading of the clause. Clause 24.1c refers to the lender taking proceedings. Clause 24.1 of MCB in the sense that Hestia and Sujana are obliged to sue in England, but MCB is not. That does not disapply clause 24.1a to MCB completely. Where it is Hestia or Sujana which bring suit against MCB in England, clause 24.1a is not disapplied by the operation of 24.1c. MCB is thereby agreeing to be sued in England subject to the liberty conferred by clause 24.1c. In those circumstances, MCB has agreed to be subjected to the exclusive jurisdiction of the English court, subject to its right to bring claims, which may overlap abroad pursuant to 24.1c, where it otherwise 24.1a would be superfluous, etc. Now, my lord, we say that really the argument that's being advanced by the defendants is precisely the argument that Popplewell J was rejecting there, and rejecting for very good, and we say obvious reasons, even if it means parallel proceedings. What Mr. Justice Popplewell is recognising, and the judge here failed to recognise, is that the jurisdiction provisions in that case and in our case operate differently depending upon who the claimant is. The defendant's skeleton at paragraph 42.1 says that the fourth sentence submits disputes to the Los Angeles or New York court. And in that sense, they seek to focus it on that issue, the dispute. They completely overlook that the clause is concerned with claims made by the defendants related to the purchase price. So, my lords, the English court, on any view, as the judge found, initially at least, he should have found remained the case, the English court had jurisdiction to deal with this claim, and indeed the claimants were obliged to issue the case here, and there was no basis upon which to stay it. Now, my lords, that was really the sole issue before the judge. The defendant's case below was that the contract did not confer jurisdiction, and there were no discretionary factors which justified a departure from the contract. That was really the entire case that the defendant advanced, and that's what stated my skeleton, and I don't understand that to be dissented from. There was no case advanced before the court below that even if the contract conferred jurisdiction, the court should somehow decline to exercise its discretion to grant a stay despite that. Now, I apprehend from my learned friend Skeleton that they do want to advance before the court today, that even if you're against them on the construction of the contract, the court should grant a stay nonetheless. And I'm going to move into submissions in relation to that, which I hope I can take fairly briefly, should the defendants be permitted to advance that case.
But the judge said, didn't he, that he would, he says at 18, I conclude that D is entitled to stay as a right, but if I am wrong on this, I consider this court should not exercise any jurisdiction which it may have.
Yes, he doesn't explain what that is, and the only reason that one can discern is because of the view he has taken on construction. As I read that passage, he is saying, I have taken a view on construction. That means that as of right, they're entitled to a stay, but if not, because of the construction issue, as a matter of discretion, I grant a stay. He's not dealing with it on any different or broader ground. He certainly doesn't suggest any such ground, and as I said, none was submitted to him by the defendant. I don't think that's an issue. I've got the defendant's skeleton argument from below if it would assist the court to look at that.
But that point seems to be pursued by way of respondent's notice.
it may be, I think, yes, in which case my learned friends will need permission to do so, to take a new point. As I say, I hope I can deal with this fairly briefly in any event, and I will endeavour to do so. The first point which arises for determination, if one gets to this stage, is in relation to the Hague Convention, which is a somewhat vexed area, as your lordships will be aware. It's been the subject of consideration in various courts. Starting.
Do you need the Hague Convention at all if you're right on construction clause in the argument that we're advancing?
No, well, I don't think I need the Hague Convention at all.
It doesn't arise on your case.
No.
And it was a fallback position.
It's a fallback position, and there's a further fallback in that even if the Hague Convention doesn't apply, when one gets to, because my learned friends, I think, say broadly speaking, they say whatever this clause says, because there are parallel proceedings, for some reason this court should stay the English proceedings. And maybe, perhaps it's convenient if I just address that briefly before getting to the Hague Convention.
Even the construction arguments or interpretation arguments, I think you just have to stand back and you look at this sort of clause and understand what it's trying to do and why it's trying to do it. Because it's quite a common technique that the basic provision is English jurisdiction. That's absolutely clear. English law and English jurisdiction. But what it's also seeing is that there might be a very straightforward claim by the defendant for the purchase price. And what it's saying is if the claimant doesn't pay the defendant the purchase price, or it's so alleged, a relatively straightforward claim, they don't need to come to England just to claim the purchase price. They can do that in Los Angeles.
Oh yes.
And that's what's going on commercially here. So all it's saying is it's English law and jurisdiction, but if you want to claim the purchase price, you can do it in Los Angeles.
My lord, yes.
That's all it is.
The point that has arisen is obviously there is an issue of interpretation. And one of our points is that if that's an issue that needs to be determined, the English court is obviously the sensible place to do so because it's an English law contract. My lord, more generally...
Sorry, for me, any discretionary arguments about this contract, it's going to be very difficult for the defendant because it's governed by English law.
My lord, yes, but I think one could go further than that, if with respect. In the position adopted by my learned friends seemed to be that, well, there are parallel proceedings, potentially duplicative, and so therefore it follows this court should stay the case. Well, why? This is the obvious court for the claim to proceed in, for a number of reasons, not just because it's an English law point, but also, my lord, there are various disputes between the parties, as we know. There is the money claim in relation to the Sony receipts, in relation to which, unarguably, this court has exclusive jurisdiction. There is the claim for fraudulent and negligent misrepresentation, which this court unarguably has jurisdiction, exclusive jurisdiction over. There is my claim for negative declaratory relief, which we say this court unarguably has exclusive jurisdiction for. And in those circumstances, this court is the only court which can deal with everything that is in issue between the parties. So it's a question of wanting to avoid parallel proceedings.
Well, then it's the defendant that has created parallel proceedings by starting proceedings in a jurisdiction it didn't have to commence in.
Indeed.
You had to commence here. The forum of the governing law and the exclusive jurisdiction clause. There are only duplicative proceedings in Los Angeles because the defendant has chosen to do so when it didn't have to do so. And you say has also included claims within that claim which have to be tried here.
Yes. And moreover, implicit in what your lordship says, they've done so despite the fact that this is a jurisdiction that they're perfectly happy with because they've agreed to it, that this court should have exclusive jurisdiction. So it's not as though they're being brought somewhere which they haven't agreed to litigate in.
You're not seeking an anti-suit injunction at the moment in relation
Well,
to those claims.
The court can only, as your lordship knows, the American court is an application pending before it. One can only speculate what it might do. I've outlined to your lordships what it would do, or what the contractual position is, and this court can certainly form a view as to that. We are confident.
You've got an outstanding motion to dismiss,
or to stay, or to, I think,
and that's what's due to be heard on Good Friday, is it?
my lord, yes. Is that the yes, that's right. And so one can speculate about what the American court might do. What this court could certainly do is to form a view as to what contractually the parties have agreed the position should be. And as I say, parties' agreed position entails necessarily that this court is the only court that can resolve all disputes. And we will hope that the Californian court will take the same view and not allow the Californian proceedings to go further. But we reserve the right, if necessary, to bring an anti-suit injunction. But one wants to act in a sort of proportionate way in relation to this, and if it can be cut short by the Californian court, then so be it. So, my lord, that is essentially what we say in relation to any discretionary exercise. In relation to the Hague Convention, I don't know whether it would really assist your lordship. I think your lordships know what I say about it, and you'll hear what my learned friends say about it. There is a dispute on the, there is some academic argument, at least as to the extent to which it applies to asymmetric clauses. But I think I realistically have to accept the force of what my learned friends will say in relation to some of the travaux preceding it. And it'll be, in an appropriate case, it'll be a matter for the court to decide whether those travaux should be allowed to determine the scope of the clause. Perhaps one point I would note about it is that Dicey and Morris, when they discuss it,
It's both Dicey and Morris and Professor Briggs, isn't it?
The same author. My lord.
Yeah, I was going to say.
It's tab 49, the only point I was going to make in relation to the Dicey and Morris discussion, one finds it at page 1418 of the bundle. It's paragraph 12090 of the text, where the authors refer to the Hartley Degacci report, etc. And your lordships will see the way that the essence of the argument is encapsulated. But what they do say, and this is perhaps significant, is they go on to say the question is not likely to be of any practical importance in proceedings in the English court, because the common law will generally provide the same answer.
Yeah.
Well, that's very much this case. If your lordships are with me in relation to the interpretation of the relevant clause, there really isn't any scope for staying the claim.
No.
Unless I can assist the court further, those are my submissions.
Can I just ask you a question about paragraph 17E of the judgment? I was just struggling to follow it. It's not something you've taken us to. It might be said that D would retain a choice of litigating purchase price claims in two jurisdictions rather than just one. This is an absurd construction. I'm not entirely sure what the judge is trying to say there. Do you have any comment on it?
I think perhaps I need to share your lordships wondering quite what it means. Asymmetric jurisdiction clauses commonly certainly allow of the possibility that there be parallel proceedings. And indeed, in the banking standard form, they often expressly permit that, because it's often, as my Lord Justice Phillips said, they're about being able to enforce where assets are.
The LMA one, which I think is the one that's in both Lorna Mead
Indeed.
and Mauritius Bank, actually says the lender can pursue proceedings at the same time in a number of different jurisdictions.
Indeed.
So
Now that
expressly contemplates.
yes, the rationale behind that may or may not apply in this case. I mean, it is possible that if a claim was brought in Los Angeles for a straightforward non-payment of the additional purchase price, but it was found that enforcement in Los Angeles was difficult, then they may want to come and sue in England if that's going to make enforcement easier.
I mean, as I understand it, the judge is here saying, if I've got this right, he's talking here about a derogation, or as he puts it, a derogation from or qualification of the rights contained in phrase 2. So he's talking about an argument that the fourth sentence derogates from the rights of the exclusive jurisdiction clause in clause 2, phrase 2. It might be said that the defendant would retain a choice of litigating purchase price claims in 2 jurisdictions rather than just 1. Do you accept that it does? Does the defendant retain?
On the face of it, as a matter of jurisdiction, yes.
Yeah.
Now, there may be questions about abuse of process and the like, but the defendant has that ability.
And you say that's not an absurd construction?
Not as a matter of construction, no.
All of this bit of the judgment all seems to be predicated on the judge's rationale that there can only be one jurisdiction for any claim. That seems to be what he said.
That's, yes, my lord.
So parallel proceedings would be unthinkable, unworkable, absurd, or whatever. That seems to be his thinking. Therefore, this somehow is to be construed on the basis that once the defendants have chosen to sue in California, that trumps everything. Hence his use of the word at the end of F about retracting the otherwise irrevocable submission.
Yes.
Which is, and then he uses his concept of a floating jurisdiction to justify that conclusion. I mean, that seems to be.
Yes, and underlying that is the idea that it's an exclusive jurisdiction in relation to the issue, rather than the party that's commenced the proceedings.
Yeah. And in a sense, that ties in with Mr. Sutcliffe's point about the one-stop shop.
Yes. Which obviously we don't have.
And I think what Mr. Sutcliffe is going to say, what we'll hear from him in a moment, is that this court should construe this clause as, on the basis of one-stop shop, is the sort of the result we should be striving for, and therefore the clause should be construed in that way. I think that's what it is.
Yes, but of course it's a result which the court can't possibly arrive at, because on any view, we've got a shop in London and a floating shop for defendants' claims. But there's even on their case, indeed they positively assert that this is not a one-stop shop.
Well, the starting point of the one-stop shop cases and the Fiona Trust sort of presumption was really to do with quasi-contractual claims or tortious claims.
It's about the scope of what's covered by
the scope of the arbitration clause. It goes back to cases on arbitration clauses.
Indeed, I think I mean, my other friends are probably quite right that it's, if you like, leached slightly into also consideration of whether clauses are to be regarded as exclusive and that.
Yeah.
I was going to ask you about the second sentence, but I think we may have covered it anyway. But I don't quite understand why it's said to be a positive encouragement to parallel proceedings, because an exchange you had earlier with Lord Justice Phillips, I thought we sort of, your submission was, well, again, if proceedings have been commenced by your clients in the only place they can bring proceedings, it doesn't automatically follow that the defendants would want to bring parallel proceedings in the US. They could even well just engage in the UK.
And indeed, why wouldn't they?
So, well, as I say, I'll ask Mr Sutcliffe the same question and try and unpick in my own head that paragraph.
Yeah,
I go for that.
thank you very much, Mr Cullen. Yes, Mr Sutcliffe.
My lords, I persuaded the learned judge below that his construction of this clause was the correct one. I appreciate I may have a hill to climb, but that's what I'm going to seek to persuade your
Well,
lords.
that's why you're here, Mr Sutcliffe.
Exactly.
Your forensic skills will.
Was it his construction or was it yours? You said you persuaded him that his construction was correct.
Oh, no, sorry. It was my submissions as to the proper construction of this clause, and
Yeah.
persuaded him.
I think
Anyway.
there's a suggestion that it actually wasn't your main submission, that there's a suggestion that the judge's floating construction was his own.
I think the phrase
Just
was
the
not one that I
phrase.
used, my lord, but the effect of what he decided is, we say, absolutely right. Now, so, just by way of introduction, what we submit is that phrase 4, and I do adopt his lordship's breaking down of that clause as
Yeah.
appropriate. Phrase 4 in clause 14 should be interpreted as an option for the respondents to require purchase price disputes to be
Sorry,
determined
an
in
option to the
California,
respondents of what?
to require purchase price disputes to be determined in California or New York. That option, whenever exercised, overrides the phrase 2 agreement to litigate in England, and so prevents duplicative parallel proceedings.
So what, you can wait until you're getting a dodgy hearing in the UK that you don't like the look of, and then actually just pull the rug out from under English proceedings at the last minute and bring proceedings in the US.
Well-
You can exercise your option at the last minute.
My lord, if I may deal
Now, I
with
just-
what actually happened, I need to consider what my lord is suggesting.
But
Obviously,
you just said that-
we would have submitted to the jurisdiction in the circumstances that your lordship is.
The effect of that argument, Mr Sutcliffe, is that the claimant can't bring proceedings at all in relation to the purchase price.
No, with great respect, my lord, that's not what I submit to your lordships, or indeed submitted below. The claimant is able to bring a claim in relation to the purchase price, but standing back, as my Lord Justice Phillips encourages, what are we talking about here? We're talking about a claim by the respondents to the additional purchase price and a claim for a negative declaration. Yes, it so happened that the royalties that were outstanding were withheld because they were far below the amount of the additional purchase price that was claimed. But that I'll come on to and show you how it's been dealt with. But that's what we're talking about here. We're talking about a claim by Mr. Manilow. And what I'm submitting is that when he exercises that option, provided, take my Lord Justice Snowden's point, he hasn't submitted to the jurisdiction, which he did not do, because as soon as he received this claim, he issued his application notice objecting to the jurisdiction.
Well, hang on, I thought, sorry, when you say hasn't submitted to the jurisdiction, so does that mean you necessarily read clause 2 down from
Yes.
this?
Yes.
So
Yes, my Lord, what I submit is that
all
option,
doesn't mean all.
that option, yes, whenever exercised, overrides the phrase to agreement to litigate in England, and so prevents duplicative parallel proceedings. And that is because in clause 14, phrase 2 is expressed to be subordinate to phrase 4 in the same clause.
But there's a proviso that you can't use the clause 4 option once you've submitted to the jurisdiction under clause in some way. So there's a proviso to your option, exercising the option.
Yes, we accepted from the outset that in relation to the royalties claim, that was a matter which the claimant had to bring and did bring, and we're not objecting to it being brought in this country.
No, but I'm just trying to understand what you say, the nature of your, you say, as I understand it, clause 4 gives your clients an option exercisable at any time on the face of it, which overrides, I think was the word,
Yes.
the exclusive jurisdiction clause in phrase 2, clause
Yes.
in sentence 2.
And
But you then qualify that because I asked you, well, could you exercise it literally at any time? Because that's the way I think you put it first. And so now you qualify that by saying, oh no, it must be qualified because it's not capable of exercise after you might have submitted to proceedings commenced using the power in
Well,
phrase 2.
my lord, obviously, if we've submitted to the jurisdiction, we can't object and say that the proper jurisdiction is elsewhere.
But why not? Because you have the right to sue in Los Angeles. So you lose that right if you lose the right to sue in Los Angeles if you submit to the claim in England.
Yes, because what we've done, my lord, is perfectly properly. As soon as that claim was brought in England, we objected to the jurisdiction, so we did not submit.
The difficulty is that sorry.
So how you, but that means you must be saying that Hipgnosis cannot properly bring proceedings in England.
No, my lord, if we don't exercise our option under phrase 4, then the proceedings continue in England. But we have exercised that option. We've objected to this court having jurisdiction over those purchase price disputes.
So it's an option to be exercised prior to submitting to
Yes.
the proceedings brought under clause
Why,
2.
why does that need to be the case, given that on your argument as accepted by the judge, what you have here is floating jurisdiction?
Well, it crystallises once we've submitted to the jurisdiction. There's a distinction between the existence of the jurisdiction on the one hand and the exercise of the jurisdiction on the other. And plainly, there is a jurisdiction for the claimant to bring a claim in relation to the purchase price in this country. But if we have objected and exercised the option to bring a claim in Los Angeles or New York, then the effect of that is to override the phrase 2 agreement. And if I can just develop that, it is just looking at the wording of the clause, which is very important and is not to be found in the LMA wording. It's the effect of the wording notwithstanding the foregoing.
But what it doesn't go on to say is Mr. Manilow has an option to require purchase price disputes to be determined in courts of Los Angeles or New York. It's not what it says.
Sorry, Lord, what it says is that
You may bring a claim.
yes, any claims made by him related to the purchase price may be brought by him in Los Angeles or New York, and then importantly, these are critical words, solely in connection with such claims, the claimant agrees to submit to the jurisdiction of the courts in Los Angeles, New York. So it's that agreement to submission which is crucial. And in relation to the purchase price claims, obviously, we say, as a matter of construction or obvious implication, if there were to be a counterclaim in relation to the purchase price, here it would be simply for the mirror image of the claim. It would be for a negative declaration. There was no such claim. Then the claimant would be able to bring that claim in those courts. It would be bringing a counterclaim as opposed to a claim. And if Mr. Manilow,
Your construction reads this option as not a carve out from clause 2, but effectively abolishing clause 2 altogether.
yes, yes.
The difficulty, there are all sorts of difficulties with it as a matter of construction. It involves reading, notwithstanding the foregoing, in a particular way. It also involves reading the word exclusive into the last part. Because true it is they've agreed to submit, but that's only, what that's saying, as I read it, is we agree not to say that the relevant US court is not a convenient forum for the determination of the dispute. What it's not saying is it isn't saying we agree to the US court being the exclusive jurisdiction for the determination of purchase price claims, not least because it's an option only in the one party and not the other.
My task, my lords, is to persuade your lordships that in circumstances where that option is exercised, it doesn't apply if it isn't, then the effect of this clause is to create two exclusive jurisdictions. One, phrase 4, in respect of purchase price disputes, and phrase 2 in respect of any other disputes relating to the agreement. And we do submit that is the proper construction of this clause. Alternatively, there is an implied term to that effect for the reasons I'll explain. And either approach to construction of this clause ensures that the risk of mirror image proceedings is avoided, and it also reflects the presumed intention of the parties. Now, if your lordships are with me on construction, I appreciate at the moment the appeal should be dismissed. And that's because my learned friend doesn't advance a ground of appeal. The judge was wrong to refuse to exercise his discretion contrary to that construction of phrase 4. But if you are not with me on construction, as a fallback, we say, first, the Hague Convention does not apply. Second, at common law, the learned judge was nonetheless right in his exercise of jurisdictional discretion to avoid potentially inconsistent declarations being given on the purchase price dispute on both sides of the Atlantic. That's the reason. And my lords, you'll hear from my learned junior, Mr. Day, on those fallback issues. Before turning to interpretation, can I make a few background points? Starting with the agreement, if I could ask you go to the supplemental bundle 1, tab 3A, page 14. If we look at the recitals, these are all obvious points, but nonetheless need, I submit, to be made. One sees the parties. An English address is given for the claimant, a Californian address is given for the respondents, and for simplicity I'll refer to Mr. Manilow as shorthand for both respondents in these submissions. Then if you go over to page 15, you'll see halfway down the page the definition of business days includes public holidays in both England and the US. Note also the reference just underneath that to US copyright law reflects that Mr. Manilow is an American artist. The record companies are American too. Then if you go over to page 17, we see at the foot of that page, clause 2, the grant of rights, which includes at 2.5 on page 19, a grant of rights under US copyright law. Then clauses 3 to 5 on pages 24 to 28 include further provisions dealing with the mechanics of the sale to Hipgnosis. We don't need to spend time on those. And then we get to page 28, clause 6, which makes provision for the purchase price. And you will note that in little a, the initial purchase price, second line, $7.5 million, that was to be paid on the closing date. And then we see an American bank account for the third respondent, B, and over the page at D, that's the provision for additional purchase price, which is the focus of the dispute between the parties in both sets of proceedings. Then if you go to clause 9, page 31, notices, Mr. Manilow is required to be notified in California with a copy to his New York attorneys. Hipgnosis is required to be notified in England with a copy to its New York attorneys. Then if we go to page 35, clause 14, which my lords have already seen, if I may develop my, I'll develop my submissions on that shortly, but at this stage I make one introductory point. Clause 14 strikes a balance that reflects the balance in the wider contract. And that balance is between English law and jurisdiction, and on Mr. Manilow's election, Californian or New York jurisdiction for purchase price disputes, as my Lord Justice Phillips observed. As we've seen, the purchase price was to be paid to Mr. Manilow in US dollars to an account in California. Mr. Manilow bargained to be paid at home, that's page 28, and to receive communications under the agreement at home, page 31. We say he also bargained for disputes relating to such payment to be, if he so wished, at home as well. Now, I only need to show you 2 items of pre-action correspondence, and I appreciate you've already been shown in supplemental bundle 1 at tab 3D, the letter at page 48, which is the letter from the 2nd of May last year, Mr. Lapine, a Los Angeles attorney acting for Mr. Manilow, to Mr. Liebowitz, a New York attorney acting for Hipgnosis. And if you look at the third paragraph down on page 48, could I just ask you to read that paragraph beginning in simple terms?
Yeah.
And then if we go over to page 51, your lordships will see that phrase 4 of clause 14 is quoted in full. Immediately below that quotation, Mr. Lapine confirms that Mr. Manilow will exercise his option to sue in California if it is necessary to litigate the issue. And at the foot of the page, last line, all Mr. Manilow's rights are reserved. And the next letter in the appeal bundle is behind tab 4, a supplemental bundle dated the 12th of August of that year, page 67. That letter is from Clinton's acting for Hipgnosis in England, not the US attorneys acting for Hipgnosis with whom Mr. Lapine had been corresponding. And this is the first Mr. Manilow's representative heard from Clinton's. And you'll see that in the 4th paragraph of that letter, before we get there, maybe in the 2nd paragraph, it refers to recent exchanges between you and our clients, New York and California Council. I do have those exchanges here if you'd like to see them, but I don't obviously need to do so. Safe to say that at that point, the parties were still in discussions and hoping to resolve the matter. And you'll see from the 4th paragraph down that Clinton state an independent party should determine the dispute between the parties. They then say that the claim has been issued in England and the claim form is attached to the letter, although it was not actually served by this letter. And I make 3 points on this exchange of correspondence. First, Hipgnosis knew that if the dispute over the purchase price required litigation, Mr. Manilow would exercise his option in favour of the jurisdiction of the California courts. Second, with that knowledge, but without prior notice, Hipgnosis commenced these proceedings seeking negative declaratory relief in the English courts. And in doing so, it failed to comply with expected pre-action conduct, including sending a letter before action. And third, we say the obvious inference is that Hipgnosis was seeking to seize the English court in an effort to undermine the option to litigate in California, for which Mr. Manilow had bargained. Now, as my lords will appreciate, that strategy turns on the construction which Hipgnosis places on clause 14, which the judge rejected, and we say this court should also reject.
Well, if they're right about their construction, then none of those points matter.
That's right.
Because they were entitled to sue here, including for negative declaratory relief.
Well,
the judge found the claim here was a proper one. Your argument is it was an improper one. That's not an argument that's before this court.
Well, my lord, sorry, to be clear, if their construction is correct, we do say, and we've said this by respondent's notice, that this conduct can still be taken into account in the exercise of discretion, and Mr. Day will develop that in due course.
Where's that? Is that in your respondent's notice?
Yes.
You can just show us.
It's in the core bundle. At page 17C, behind tab 2.
Yeah.
Paragraph 2, if necessary, the court should not exercise any jurisdiction given the risk of parallel duplicative proceedings and inconsistent judgments, especially given that risk has been brought about by the conduct of the appellant, who, having been told in correspondence proceedings will be commenced in Los Angeles, preemptively began proceedings in England seeking negative declarations.
Well, what's wrong with that on your on their interpretation, there's nothing wrong with them bringing proceedings in the UK. And on your interpretation, there's nothing wrong with them bringing proceedings in the UK because you have an option that allows you to trump it.
Well,
so why do you say there's something wrong with, on either interpretation, what's wrong with what they did?
What we submit is that the court, in exercising its discretion, as the learned judge did as well, it would be right to allow the Californian proceedings, which are in existence, to go ahead to determine the matter in relation to the purchase price, and one of the matters that can be taken into account is the circumstances in which these proceedings were issued without complying with pre-action conduct, when they knew that Mr. Manilow intended to bring those proceedings in California. So, and as I'll come on to show you, reliance does appear to be placed on the fact that Hipgnosis got in first. Now,
But there are duplicative proceedings because your clients decided to start a second set of proceedings in relation to the same subject matter. You didn't have to do that.
well, my lord, again, as I say, it was very clear that the purchase price dispute was going to be litigated by Mr. Manilow. He'd given notice of that back in May.
No, well, hang on a moment, because the truth is, he may have done that, and there's a lot of posturing and correspondence, some of it quite offensive. But the reality is that once the claimants had commenced the proceedings in England, and your clients were well aware of those proceedings before they sued in Los Angeles, they didn't have to sue in Los Angeles. They could have said, oh, well, they've now sued in England, we'll proceed in England. That's what the clause says.
That's a contractual right that Mr. Manilow has, and he's
I'm not
exercising.
suggesting he didn't have it, but the fact is, if one asks some sort of question, why are we in the situation where there might be duplicative proceedings? The short answer is because your clients chose to sue in Los Angeles. Exercise
The other way of looking at it, my lord, is that we're in this position because these proceedings seeking declaratory relief, negative declaratory relief, were issued in this country in circumstances where Hipgnosis knew full well that Mr. Manilow was intending to issue in Los Angeles if the dispute couldn't be resolved. He was attempting to resolve the dispute.
But
As
the claim
these-
you've
as this
the claim you've
corresponds-
issued in Los Angeles includes claims for fraud and fraudulent misrepresentation and negligent
which
misrepresentation.
should clearly be brought in England.
Well, my lord, that is a matter which is before, as the documents in the Los Angeles proceedings show, that's a matter which is before the Los Angeles court to determine. It's
Well,
not.
it may be
It's not
before the Los
something that's
Angeles
been.
court, but if what you or Mr. Day are inviting us to do is to exercise a discretion by reference to the way in which parties have conducted themselves, which seems to be the submission you were making in relation to the claimants having sued in England, we surely are entitled to take account of the fact that in the United States, so far as this court is concerned and English law is concerned, your clients have brought claims they're not entitled to bring in the States for whatever tactical reason of their own. Those claims should be brought in England.
The question which the
And the California court might say, you're perfectly entitled to bring those claims, but that doesn't stop this court from saying these are claims that should be within the exclusive jurisdiction clause.
yes,
And what sauce for the goose is sauce for the ganders.
my lord, no, that is a matter that is currently before the Los Angeles court. The point has been taken that these fraudulent and negligent misrepresentation claims do not relate to the purchase price, but that's a matter to be determined. But it doesn't affect the position, in my submission, that Mr. Manilow had the right to bring his claim for additional purchase price. That's what this matter is about in California.
He did, absolutely. But your argument is, on this basis, is on the assumption you're wrong on the question of construction of the clause, isn't
Yes,
it?
you're
And
right.
so, although he was entitled to bring the claim there, the claimants were entitled to bring the proceedings here.
Yes.
And once they brought the proceedings here first, should those proceedings be stayed so that you can continue proceedings in Los Angeles against not only in relation to the purchase price, but also in relation to matters which plainly should have been litigated here?
Not avoiding your lordship's question, but that is something which we're developing in the context of the respondent's notice and matters that Mr. Day is going to be dealing with, so will certainly be dealt with, and from what the auditor says. Now, can I just turn next to the relief sought in these proceedings, because that was something that my learned friend Mr. Cullen touched on, and if I can ask you to go to Core Bundle tab 10, page 57.
Yeah.
You will see the matters that have been stayed are the declarations,
I'm sorry.
sort
can
of
you-
paragraphs,
Sorry, can you just give me the page reference again?
sorry, my lord, page 57 of the core bundle.
Cool.
Core.
Yeah.
And this is his lordship's order. The matters that have been stayed are the declarations, paragraphs 1B and C on the purchase price. No stay has been ordered for paragraphs 1A and 2 to 5, which are not concerned with the purchase price, and we accept fall within phrase 2, not phrase 4. Those claims concern the Sony receipts, and what happened, my lords, was that the parties agreed to defer all issues on the Sony receipts claim until the jurisdictional challenge to the purchase price claim was determined. That claim was admitted promptly after receiving the judgment on that challenge, and we address that at paragraph 13 of our skeleton argument, which is Core Bundle tab 4, page 28E. Now, I obviously,
Core bundle page.
Core Bundle tab 4, page 28E, it's our skeleton. Paragraph 13. We refer there to the correspondence, and the short point.
Sorry, you say 13. I thought you said you'd admitted the claim.
We have.
Okay, so
The short point.
either for how much, or the point is, how much have you admitted? Or have you admitted that there's going to be an account?
Yes, that was the claim, was for an account. That's been, what effectively my client has done, and I can take you to the letter, in fact my learned friend took you to it at the outset of his submissions. My client has admitted liability for that claim and has made a payment of $500,000 covering the second half of 2022 and the first half of 2023. The parties are still corresponding about payments for any later periods of time, plus interest and costs. Because it appears that on speaking to Sony have said that my clients have been paid in respect of a further period, but instructions are being taken on that, and Sony are being asked about when that payment was made. But the important point is that the correspondence is focused on agreeing numbers, not the question of liability. So if the English proceedings continue, their sole, or at least principal focus, will be the declarations which are the reverse of what is sought in California. And to take up my Lord Justice Phillips' point, we accept an account will need to be taken if the remaining number can't be agreed. $500,000 has been paid, the exception account will need to be taken. If it can't be agreed, but we hope that it can. Now, so the sole issue, we say, will be the declaration. So the live issue will be the declarations that are the reverse of what's sought in California. Mr. Day will come back to that.
Can I ask you this? I understand from in the agreement that your obligation is to pay any royalties that you receive that are effectively assigned to Hipgnosis under the agreement without set-off or deduction.
Well, my lord, that is absolutely right.
Yes. But there's no equivalent provision in relation to the purchase price, is there? There's no set-off provision on the purchase price.
No, does your lordship intend to refer to the additional purchase price?
Yes. So although you can't set off the purchase price against the royalties, it's not clear to me why they can't set off any sums you owe them, especially the royalties against the purchase price.
Well, my lord, well, I suppose that must be right, but they're seeking a negative declaration that no additional purchase price is due. They haven't asked for a set-off. I'm not quite sure.
Well, the only point here is that it seems to me that if that's right, then you can't draw a neat line between purchase price claims and the claims which are being made in the English proceedings.
Well, my lord, I'm not sure I would accept that, particularly because now that claim has been admitted. And so all that is left is for there to be an account and a calculation of the appropriate interest payable and costs. And so there is a clear distinction in my submission between the purchase price claim and any other claim.
I mean, are the amounts that have been admitted or paid by your clients peanuts?
Well, I suppose it depends on one's view of peanuts. No,
Well,
£500,000 has been claimed.
More specifically,
I know what my lord's referring to.
Yeah, and I'm
Yeah.
just the letter that you say meant that Hipgnosis's conduct of issuing proceedings in the UK was improper or should be taken into account in some way. Actually invited them to make a claim in the UK. Described it as peanuts, and I'm just checking it's the same claim that was invited, that they were invited to make, and I assume it is.
I'm not sure what I think what the American attorney is saying is that the amount of the additional purchase claim far exceeds any royalties that may be due. And as my learned friend
That's not what he
made the
says.
point.
I mean,
Well-
he's saying, should we proceed to litigation, my client can and will pursue $1.5 million plus its attorney's fees in Los Angeles, while your client can pursue a claim for peanuts in the UK. So, I mean, he's first of all, he was suggesting that if there was to be litigation, that they should bring a claim in the UK, which they have done and have claimed amounts which probably don't seem peanuts to most of us. But that's the claim he was talking about. So is the impropriety only in bringing the claim in relation to the purchase price?
Yes, absolutely, my lord. The point is that there was a royalties claim, and as my learned friend pleaded, there was no right of set-off or in relation to that, and without waiving any privilege. I mean, that obviously may have been a factor that was taken into account in admitting the claim, but at the time it was hoped there would be a resolution through compromise, and obviously the fact that what we don't know quite happened, it appears that Sony had paid through monies to my clients.
But let me get this right. You say, look at this letter from the US attorney, what they did was terrible. It ought to be taken into account. what they did was to issue proceedings as invited by the US Attorney in relation to the Sony monies. Yes. And so the only thing that you could say that they did which was wrong and terrible and ought to be taken into account is including within the claim a claim in relation to the purchase price.
Lord, I think what I'm submitting is that the pre-action conduct was not followed, and that had what your Lordship's just described been set out in a pre-action letter, then Mr. Manilow would have had the opportunity to bring the purchase price claim, and only that, in Los Angeles, and to receive advice, whatever. I don't know what, I wasn't involved at that stage, in relation to the royalties claim, which, as your Lordship rightly says, was to be brought in this country. It couldn't be.
But are you saying that they were unable, because of the construction of clause 14, to bring the purchase price claims in the UK?
No, they could bring.
So you accept that they can bring purchase price claims in the UK under clause 2?
Yes, but Mr. Until the option is exercised, all I'm saying is that it wouldn't have been necessary for them to bring the purchase price, any purchase price claim, which is in effect Mr. Manilow's claim in the UK. They would have, if they felt there was any counterclaim to bring in relation to the purchase price claim, they could have brought it in California, or, as was their right in relation to the royalties claim, bring it in this country.
Well, they were entitled, their particulars of claim in the English proceedings are essentially making 2 points, aren't they? One is they're entitled to be paid in royalties without settle or counterclaim, and there's remaining dispute as to whether there's an outstanding payment by Sony that needs to be accounted for. And the second point they're making is that there was no additional purchase price for the reason that they set out in their purchase price. So far as that's concerned, so far as that argument is concerned, I'm struggling to see what was improper in bringing that claim in England.
Nothing improper in bringing it, my lord.
If they're right about, obviously, if you're right about construction of clause, paragraph, or fourth sentence,
yes,
then none of this matters because there's exclusive jurisdiction, Mr. Manilow, and that's the beginning and the end of it.
that's right.
But if you're right, what you're inviting us to consider is even if you're wrong, the judge was right to grant a stay, and I find that, I'm afraid, I'm really struggling in seeing what was wrong with the claim they brought.
Well, my lord, can I suggest that that comes at the end of our submissions, and if I can deal with it then on the question of discretion. Can I just complete the background?
That's the trouble, Mr. Sutcliffe. You've lured us down this road.
I know, it's all my fault, my lord, it's all my fault. But to complete the background, can I show you the motion by which Hipgnosis challenges the jurisdiction of the California court? Now, that's in the unagreed bundle. And rather than having
is this more prejudice that you want to?
No.
Or are we? Is it going to help us construe clause 14?
The approach taken is in my submission important. What the purpose of showing it, is to show how the purchase price use is necessarily duplicative and at risk of producing inconsistent judgments. Now, this is not evidence. These are simply documents that have been submitted to the California court, which are going to be the subject of consideration by the California court. Although I'm amazed it's on Good Friday.
Yeah.
My lord pointed that out. So
Tab 1 of the unagreed bundle
Yes, thank you. Page 3. We see 3 bases for the challenge. First, construction of clause 14. Second, forum non-conveniens. And third, comity. And then we see at the foot of page 13, if you can go to page 13, clause 14 set out in full. And at lines 10 to 13, Hipgnosis acknowledge the option allowing Mr. Manilow to litigate the purchase price dispute in California. It is no part of Hipgnosis's position in the English proceedings that so far as the purchase price dispute is concerned, the Californian proceedings are in breach of clause 14. And then at page 15, under the second heading, Hipgnosis fall back on a broader forum non-conveniens objection to the California proceedings. And we see from page 16, lines 7 and 8, Hipgnosis avert that the English proceedings, lines 7 and 8, deal with, and I quote, substantially overlapping issues relating to the purchase price. And then if you go over to page 17, under the heading private interest factors favour dismissal, from line 13 onwards, Hipgnosis argue England is the more appropriate forum, primarily because of the location of its witnesses. And then if we go to page 19, line 5 onwards, Hipgnosis comes back to the point that these are duplicative parallel proceedings and takes the point on the English proceedings being first in time. You see that at line 5, initiated first, and it says in which Manilow has already appeared subject to objecting to jurisdiction for the purchase price claim. Then it says if this action proceeds, Hipgnosis will be subjected to a multiplicity of actions concerning the same underlying facts and issues, effectively fighting the same allegations on multiple fronts. Well, multiple, certainly 2 fronts, definitely. We agree. Page 21, they then turn to the comity challenge. And my lords will see from the first paragraph under this heading, which runs on to the next page, this effectively repeats the forum non-conveniens arguments about parallel proceedings covering the same issues. And again, this comity argument is premised on the fact that Hipgnosis issued the English proceedings first. If Mr. Manilow had issued first in California, the argument would fall away. So with that background, I turn to the question of interpretation of clause 14. And I start, if I may, with some submissions about the relevant principles before I address the wording of clause 14 itself. Now, my lords are obviously familiar with Fiona Trust, so I will go there only briefly. But if I could ask you to take up Authorities Bundle 1, and go to tab 12. And
Just before you, sorry, you may have already left the American document, sorry, but at page 21, which you took us to, when we're talking about international comedy, you drew attention to this international comedy arguments which then followed.
yes,
Maybe the point for Mr. Day, I may say, but before, at the top of page 21, there's the point which we touched on earlier, that there are certain claims that must all be litigated in England pursuant to the exclusive jurisdiction clause in phrase 2.
well, effectively, what we submit is that the only material claim now to be adjudicated in either jurisdiction is the purchase price claim.
Well, so you're giving up your claims in fraud and negligence in the US, are you?
Well, no, my lord, as I explained, that's a matter to be to which objection is taken. It's an
No, I'm just asking your clients whether they are continuing to pursue or wish to pursue their fraud or negligence claims.
Yes. As far as I'm aware, my lord, I can't obviously predict what's going to happen in the
Well, I think
Los
the short
Angeles
answer
court.
is yes. I mean,
Yes.
you're being put on the spot, frankly, because you won't have instructions to abandon claims.
No.
But we have to assume that your clients, having made those claims, intend to pursue them in breach of clause 14 on any view, whatever clause 14 means.
Well, my lord, I say that they're before the American court, and the American court applying English law will decide whether they are or are not in breach of clause 14. They're not before this court.
No, they're not. But as I said a moment ago, in relation to the question of discretion, you're entitled to take account of the fact that those claims.
I understand what my lord is saying, and we'll come back to it. But
Anyway, you were taking us to Fiona Trust.
yes, page 154, paragraph 3. What we see is Lord Hoffman setting out the arbitration clause, which the parties were considering. Goes over the page to D on the next page. And then, if I could ask you to read paragraphs 6, 7, and 8. Then I could ask you to go to paragraph 13, 157, and to read that. And I ask you to note the reference to unless the language makes it clear. Now, this is what my learned friends already, my lords referred to as the one-stop shop presumption.
Yeah.
Now, that applies in a modified form where multiple fora are agreed, as is the case for clause 14. In those circumstances, it cannot be assumed or presumed that the parties intended all disputes arising from their relationship to be determined in a single forum. Clearly they did not. But the presumption remains that the parties did not intend or expect the same dispute to be tried in duplicative parallel proceedings with the risk of inconsistent judgments. And subject to any contrary language or context, it can therefore be assumed that the parties intended, in the context of this clause 14, that any particular dispute would go to one chosen forum or another and not be determined in fact. Put another way, the parties are normally assumed to intend the chosen forums will dovetail rather than overlap.
So why do you assume that the answer is that the chosen forum for purchase price disputes would be the United States of America?
Because that, in my respectful submission, my lord, is precisely what phrase 4 says. If Mr. Manilow exercises, he has an option.
The claimants can't bring a purchase price claim anywhere, if you're right.
My lord, they can. They can. As his lordship below found, we criticise them for doing so, but whether that criticism is justified is a matter of further discretion. But they can bring a claim in relation to a negative declaration they sought in relation to the purchase price. But if Mr. Manilow exercises the option, his contractual option, to bring that claim in California or New York, then that claim must be stayed and determined in California or New York.
On a lack of jurisdiction.
Yes,
Exercise of jurisdiction.
the exercise of jurisdiction.
Well,
There was jurisdiction. There's a distinction, my lord, between the existence of jurisdiction. Clearly, jurisdiction exists for the claimant to bring, and indeed Mr. Manilow to bring claims in relation to purchase price in England. But if he exercises his option, which he has,
So the effect of his excising option is that the claimant's right to bring a claim is effectively extinguished.
that claim is stayed as the
It's
order
the same
provides.
And
But-
I mean, the judge wasn't prepared to strike it out, but he did stay it.
Yes, but because that dispute has to be determined in the States. Now,
that's a lack of
it was
It's
jurisdiction.
the same point, though. It's a jurisdiction point. And the judge has decided that the effect of this clause is that once you exercise the option, I mean, it's what he's, I forget exactly how he puts it now. It's the end of paragraph 17.5 of his judgment, isn't it? He says
The retraction of jurisdiction.
retraction, effectively, that it's extinguished. Retract the defendant's otherwise irrevocable jurisdiction, submission to the jurisdiction.
yes, yes.
I think it's really, forgive me, I
that's
think it's
right.
really important that we have clarity about this, because I think there's a degree of moving between the two. There are two very different positions. One is to say that for some reason or other, the English court loses jurisdiction. That it had jurisdiction, but in some way it's lost it. So you've got a right to a stay as of right, and that's what the judge found. And if we're going to say that the English court lost jurisdiction, I think one has to identify the mechanism and the law which says that jurisdiction can be lost once, if it was, and I'm not aware of any such jurisdiction, and I think it's contrary to Court of Appeal authority.
Well,
And
Lord,
let's put the distinction to you. The second distinction is a power to stay proceedings which are properly founded as a matter of jurisdiction, which is the discretionary question, which I understand Mr. Day is going to address. So, which is it that you're addressing? Are you saying that jurisdiction, which was proper jurisdiction, which was founded, and proceedings which were issued validly under a jurisdiction clause has somehow been lost? And if so, how has that happened?
well, my lord, yes, I do say that first, and Mr. Day will pursue the second on the discretion point. But in relation to whether it's characterised as jurisdiction lost, effectively, the effect of that option in phrase 4 being exercised by Mr. Manilow is to require, because, and this is a very important point of agreement to submission by Hipgnosis in the American court, it requires that dispute to be determined, and only to be determined.
But if you're
in
right,
California.
I don't understand. The English court is seized because the claim has been issued and served. The English court has jurisdiction. How is that jurisdiction lost?
Well, we objected to jurisdiction in relation to the purchase price claim, so it only is seized of the royalties claim. That's
But
all
you,
that
but
we
you
accept.
determine jurisdiction as at the date proceedings are commenced, don't you? You don't determine it at some later date. There
Well,
are all sorts of problems with that.
When the claim was issued, we immediately put in an application saying the purchase price claim needed to be resolved.
Well, you didn't. I mean, there was an 18-day period, or how long it was, 15-day period, during which so the claim was commenced on the 12th, I think it was the 12th of August. Is that right? It was the 12th of August?
But the party,
So
the
when
claim
the claim was
issued.
issued in England, this court had jurisdiction over that claim.
Well, yes, but
And it was
So
properly,
where,
and
so
it was properly served.
properly served,
As a matter of
judge
jurisdiction.
found that the proceedings were properly commenced. When and how did the English court lose that jurisdiction? And on what legal basis?
Mr. Day is very keen to say something. Well,
What's the answer?
assisted by Mr. Day, the answer is, my point, I'm still going with Lord Justice Phillips to distinctions, but I accept that in both matters, it is a discretionary matter, Mr. Justice Brandon in Eleftheria.
So the court
But-
had jurisdiction, but when the option is exercised, the court ought to exercise its discretion to stay the proceedings. Is that the argument?
Yes, because of the proper interpretation of that clause.
So it's not a question of having lost the jurisdiction. So the judge is wrong in his analysis. on
Well,
that
what
basis.
his lordship did was he stayed the claim.
But you do that because there's no jurisdiction. Or you don't exercise.
You don't exercise jurisdiction because you don't exercise the jurisdiction because on the proper construction of that clause 14, the appropriate place for that claim to be determined is California.
So you're not supporting.
That's a sort of discretionary argument, which I don't read the judge as having decided on that basis. And there's no hint of California being more convenient or anything of that kind. It's all done on the basis of jurisdiction.
Well,
hence the retraction point.
I'm 16 with the judgment.
It's,
In paragraph 16.
and I'm sorry to keep pressing you about this, but it is, you know, I think we're all finding great difficulty in understanding the judge's analysis. And the judge talks about a floating jurisdiction, which seems to be suggesting that when the option's exercised, what was originally a jurisdiction in England is replaced by a jurisdiction in California.
Well, Manilow,
15 and 16.
if I could ask you to look at tab, core bundle tab 7, page 39, which is His Lordship's judgment, paragraph 15 and 16.
Sorry, which paragraphs?
15 and 16 on page 39. This is, I think, what His Lordship, it was certainly how I sought to argue it below. Although there's a discretion in the courts to decline to enforce an exclusive jurisdiction clause, which is what I said this was in relation to the purchase price dispute. See, for example, Donahue and Armco. That discretion is rarely exercised. Starting point is to construe the jurisdiction clause in question, give it due effect. There's common ground, indeed the contrary could scarcely be argued to phrase 1. Construction was a matter of English law. The defendant placed considerable weight on the decision of Mr. Justice Brandon in the Eleftheria, and an essay by Mr. Day, as it happened, on that case published in the textbook. I entirely accept the very considerable importance that attaches to party agreement. The question is, what does clause 14 actually provide in terms of that agreement? And then he goes on. So in my submission, what His Lordship, the approach taken by His Lordship was entirely orthodox. And
No, I'm sorry, Mr. Sutcliffe, you're not going to get away with that. The judge is, he's reciting discretion, and the discretion issue based on the theory. But he then asks himself the question, what's the clause actually mean? And there's a whole of 17, we needn't go through all of that, we talked about the derogation. But if you go to the end of 18, what he then concludes is that the proceedings in England were properly brought. There was jurisdiction, but there was a floating jurisdiction, which, as he says, that commencing the proceedings in the States, exercising the option, crystallised the floating jurisdiction between England on the one hand and Los Angeles, New York on the other, in favour of Los Angeles. So what he's saying there, and this is, I think, the ratio of his decision, is that whatever the position might have been in England to begin with, what's crystallised by the exercise of the option is that there is jurisdiction only in Los Angeles for these claims, for the purchase price claims. It's got nothing to do with discretion at all.
he goes on to say the defendant is entitled to a stay as of right.
Yeah.
If I'm wrong on this, I consider
That's
this
not
court should
words of
not
discretion.
exercise any jurisdiction.
Those aren't words of discretion in this respect.
Well, no, but what he has done is, in my respect, rightly so, attached very considerable importance to the proper construction of clause 14, and in circumstances where he found there was exclusive jurisdiction in California and New York to determine the purchase price dispute. That was the way in which Donahue and Eleftheria, the court should decide the matter.
Can I have a go at this? I mean, only because the words floating and crystallisation sort of seem to be a nice sort of image, but actually I just wonder whether they're remotely appropriate. At the start, in phrase 2, each party irrevocably submits for all purposes of this agreement, including any such dispute or claim to the exclusive jurisdiction of the English courts. Do you say that that includes at the time that the relevant paragraphs relating to the purchase price of the English proceedings were issued, when the purchase claim was issued. Do you say that that irrevocably submits, applied to the English dispute in relation to the purchase price at the time it was issued? In other words, had your client irrevocably submitted under clause 2, and if not, why not?
My lord, he hadn't submitted.
He had
because
not.
No, because in my submission, he had issued, he'd exercised his option 16 days after the claim was issued. He had not submitted to the jurisdiction, and he therefore raised the dispute as to what the clause 14 meant. And in our submission, as I said right at the outset, the effect of the wording in phrase 4 is to override
But I thought
the
I
wording
thought-
in
sorry,
phrase 2.
I thought you
He
said
had
that.
already submitted to jurisdiction, irrevocably submitted,
I thought that the clause 4
That's the answer to the whole thing.
for all purposes.
It is, the clause, it is.
It's a complete answer to all of it, frankly.
The
Unless you rewrite that second sentence or do what the judge did, which is just ignore it, or say that somehow it was sort of derogated from or excised or whatever. You can't get over the fact that at the time when the proceedings were issued, on the 12th of August, your clients irrevocably submitted for all purposes to the jurisdiction of the English court. And that's why this has got nothing to do with Fiona Trust or one-stop shops or whatever. It's a clause that overall contemplates the possibility that there may be parallel proceedings in two jurisdictions.
Well, my lord,
If you choose to issue proceedings in the States.
Well, the effect of phrase 4 is that the submission to the English jurisdiction is revoked.
Yeah, so how do you revoke, the judge used the word retract. I mean, forget this floating stuff, because I don't really
Yeah.
get, it's not like a floating charge or something, you know.
No.
There's no sort of jurisdiction ship bobbing around in the Atlantic. It's, as I understand it, you say the judge was right to hold that by the issue of proceedings in the US under the 4th phrase, there was a retraction of the irrevocable submission that was under clause 2. And in paragraph 17F of the judgment, the judge says the effect of the words notwithstanding the foregoing is to preserve the choice and to retract D's otherwise irrevocable submission to the English clause.
Exactly.
Where does he get the word
Exactly.
otherwise from?
Well, the effect, that is the effect of the words notwithstanding the foregoing.
So there's an irrevocable jurisdiction which isn't irrevocable.
That's right, because of notwithstanding the foregoing.
In clause 2. So it's
But commencing proceedings in California, as you're entitled to do, doesn't entail revoking submission to the English court's jurisdiction.
Well, it does, my lord, in relation to the purchase price dispute, because of the important words at the end of that notwithstanding the foregoing, phrase 4, which provide that in those circumstances, Hipgnosis has to submit to the jurisdiction of the California or New York court.
What's exclusive jurisdiction then?
Well, my lord, that's what it is. That's what it is. And if I can develop my argument, I shall show you why the authorities support that.
If the second sentence had said each party irrevocably submits brackets subject to the 4th sentence hereunder, close brackets, then your argument might have better legs to it. But it says for all purposes.
Well, my lord, in my respectful submission, the words notwithstanding the foregoing have that effect.
Well, that's
His
what you
lordship so find in my submission that he was absolutely right to do so. And they effectively override what is in phrase 2, and what is critical is the last bit of phrase 4. Hipgnosis hereby agrees to submit to the jurisdiction. So that's effect. Now,
I suppose you could say, on any view, the phrase 4 must qualify the words in phrase 2 exclusive jurisdiction.
Yes. Yes.
So I suppose you say, well, on any view, it must, on any view, it can't be exclusive jurisdiction of the English courts in relation to a phrase 4 dispute. So I suppose you say, well, you might as well do a bit of violence to the word irrevocably submit as well.
My lord, it is the
Today's nodding at least, but
it is the extent. You're right. It is the extent of the qualification imposed by the words, notwithstanding the foregoing, combined with the agreement to submission jurisdiction of the California or New York courts. So that is precisely. And what I need to show you, so I'm coming on to that, is how different this clause is to the LMA clauses that are being considered, and how there is, in particular, in the case of BNB Paribas and Trattamento, a case in which my Lord the Chancellor was one of the judges.
Sorry, what case is that?
Trattamento, BNB Paribas. I'll take you to it in a moment, my Lord.
Okay,
You,
all right.
Lord Justice Hamlin gave the judgment with which your Lordship agreed. But that's why the judge attached significance, and we submit he was right to do so.
Is this your aid memoir by putting clauses side by side?
Yes,
Okay, this is not-
I'll come on to deal with that if I may. But
Yeah.
the submission that I was making is that there is still a presumption on the facts of this case, where we're dealing with one clause and two jurisdictions, and that the parties intended any particular dispute would go to one chosen forum or another and not be determined in both. And parties are normally assumed to intend that chosen forums would dovetail rather than overlap. Now, there are a number of cases dealing with this, as your Lordships know. Normally, where a single transaction is made up of a package of multiple contracts, each with their own choice of forum. And in my submission, the same approach applies where the package is a single contract in the transaction that nominates multiple fora. And the parties are presumed to intend that the various fora chosen are mutually exclusive. And those authorities are helpfully drawn together in this court's decision in Trattamento,
Okay, what's that then?
and it's in Authorities 2, tab 29. And if I can just ask you to go first to page 601, just on the background, and paragraph 14, you will see there,
Sorry?
14, top of the page,
Yeah.
the courts of Turin are chosen in the financing agreement, referred to as the FA. And then if you go over to page 602, paragraph 19, the English courts are chosen in relation to the related swap contract. And Mr. Justice Robin Knowles concluded the dispute at first instance fell into the English jurisdiction agreement, and this court, in the judgment from Lord Justice Hamlin, upheld that on appeal. And the discussion of the principles begins at page 610. And when you're there, you'll see it's just below little c, the approach in the interpretation of the ECJ, the English jurisdiction clause, and the ICJ, the Italian jurisdiction clause. And then paragraph 65 sets out a long quote from the judgment of Lord Justice Beaton in the Trust Risk Group, which we can pass over for present purposes. That goes right to the foot of the next page. And then on page 612, paragraph 66, Lord Justice Hamlin draws together some key points and references from the Trust Risk Group, which, if I can just ask you to read. And then paragraph 67 quotes from paragraph 35 of Mr. Justice Popplewell's judgment in Mond Petroleum. We quote this at paragraph 28 of our skeleton. That's tab 4, 28 little I. What his lordship said there is where there is more than one agreement between the same parties and they contain conflicting dispute resolution provisions, the presumption of one-stop adjudication dictates the parties will not be taken to have intended that a particular kind of dispute will fall within the scope of each of two inconsistent jurisdiction agreements. They will fall to be construed on the basis they are mutually exclusive in the scope of their application rather than overlapping if the language and surrounding circumstances so allow. Nevertheless, the possibility of fragmentation may be inherent in the scheme of the parties' agreements, and clear agreements must be given effect to, even if this may result in a degree of fragmentation in the resolution of the disputes between the parties. Now, we respectfully endorse paragraph 35 as accurately capturing how the one-stop shop presumption works, where multiple fora are nominated in a contract or series of related contracts. And then in paragraph 68, Lord Justice Hamlin states his conclusions. If I could just ask you to read that, it just goes over to the top of the next page.
The question is whether we fall within 68.6.
Yes.
Or in Mr. Justice Popplewell's terms, paragraph 36. I mean, I don't know for sure, but he may very, I was trying to work out whether the judgment in Monde Petroleum was before or after his judgment of Mauritius Bank. You may not know the answer.
They're both in the bundle, my lord, so we can find out.
Double check.
We'll check. I think it may
It
be.
was after, was it?
I think so.
I think it
But
must
in
have
any
been
event,
after, actually, mustn't it? Because it was
I think
2013.
it was after.
He may have had in mind that sort of case. I don't know. Because I think he talks in Mauritius Bank about overlap, doesn't he?
Yes, I'll come on, I may, to
Yeah.
that case. But finally, on this case, can I ask my lords to note page 614, paragraph 76,
Sorry.
76, top of page 614.
Yeah.
And what his lordship is saying is that clear language is required to displace the presumption that duplicative parallel proceedings are not intended. Now, both Fiona Trust and Trattamento were concerned with the material scope of the jurisdiction or arbitration clause. And in our submission, the same or a similar one-stop shop approach is taken when deciding whether a choice of forum clause is exclusive or non-exclusive. It's simply another fact indicating the parties' intention for mutually exclusive fora. And I was going to take you onto the case of Anchorage Capital, another BNP Paribas case, but it might be a convenient time.
Right, it's probably better to do that 2 o'clock, Mr. Plunkett. 2 o'clock then, please.
Call rise if able.